So, Andrew, these jury instructions, there's 55 pages of them. I mean, we've talked about this, you and I, offline a lot. Is there a disadvantage to the fact that these jurors don't actually have their hands on these jury instructions, or does it actually, there's a school of thought that I was thinking about myself, maybe it actually helps the prosecution that the jurors don't have these jury instructions because there is some complexity to the legal concepts that are here?
You know, in the federal system, it's left very much to each judge to decide whether they want to send a written copy back or not. And I know some judges who do, some judges who don't do that. And I think it's because there's sort of upsides and downsides because, yes, you definitely want them to understand the law, but, you know, this isn't sort of a biblical exegesis where you want them to get hung up on certain words and to obsess over that, as opposed to understanding, you know, what are the legal parameters, but then really digging into the facts. And so I think, you know, again, there are upsides and downsides. In New York, they're simply not allowed to send that back, as I understand it. And so that's why the judge will reread certain portions. And that's very common. We are officially now in the tea leaf part of the, this case, which is we're all going to be looking at each note, trying to figure out what's going on. There's no question, I agree with Adam, that this is a good note in terms of assessing the jury. It's a good note if you're the prosecutors, but we're still a long way away. But I do think the big picture is kind of the one that you said, Katie, which is if you start with Donald Trump denigrating the process, all three of us do not know what's going to happen, but all three of us who've been in the courtroom day in and day out, we know to our core that this is a fundamentally fair process with good lawyers on both sides and an eminent judge presiding over it. So, you know, that I think is the real take-home message for no matter what happens in the case. It has really been handled superbly.
So, Adam, there is something that you just mentioned a couple of minutes ago. It's the unlawful means definition. And I'm actually thinking if I'm the prosecution, I would want the jury to actually have this specific definition, because if you look at it, it says that there is no requirement for the jury to unanimously find or agree upon the unlawful means by which Donald Trump was able to corruptly, reach the felony that they have in this case. And that gives the jury the opportunity to consider three different ultimate, ways by which this happened, or a myriad of ways that this happened. So, is there enough clarity, though, do you think, going into the jury deliberations today after those very long closings yesterday, which I thought were effective, but they definitely were long? Do you think there's enough clarity for this jury?
I think there is going to be clarity because this jury is seeking it. They are asking for the instructions, and specifically this instruction, yes. Unlawful means. Now, if they aren't clear about this, I would expect they're going to ask for more instructions. This is an instruction that took on a life of its own. After it became public today, a lot of commentators kind of took it out of context and made it sound like the judge was turning the concept of jury unanimity on its head. But that's not what this does. And it's a really interesting moment because last week, no person other than Trump's own attorney, Emil Bove, had said that this was a usual instruction. I actually brought the transcript from last week Sure. because it's really a very interesting moment. He said, we submit, and he was arguing to get a departure from the instruction. He asks the judge, we submit that the jury should be required to make a very specific finding, as specific as Your Honor's discretion would permit. So it's very clear what happened at trial. The judge asked him, do you agree that's not ordinarily required? Mm-hmm. Emil Bove replies, certainly. And at that moment, he makes a concession. This is how it happens. Under this election law conspiracy, the jury has the discretion to decide which were the unlawful means. And in this case, there's a wide variety out there. The falsifying business records, this is one kind of choose your own adventure for the jury. The jury can decide that all those shell companies that Michael Cohen created after calling Donald Trump and going into First Republic Bank, that those bank records for those shell companies contained lies as attested to by a witness. They could find that federal election law was violated. They could find that the 1099s for the tax authorities were misleading. And if that is too many options for the jury, that's the nature of the case. That is the widespread nature of the concealment that went into the disguising of this hush money.
You know, Andrew, that's a buffet of criminality that Adam has just offered up to us. But I do think one thing that's been a critical part that we heard through the closings and also that we're seeing woven throughout the jury instructions is this issue of witness credibility. And what was remarkable to me and something that stood out to me during these jury instructions was that accomplice as a matter of law jury instruction that was tailor-made for Michael Cohen's testimony, stating that in New York, you cannot convict a defendant based solely on the testimony of an accomplice. You have to have some corroborating evidence, which is why that first note that came out from the jury, I'm really stuck on the fact that they were asking for David Pecker's testimony, not only concerning that 2015 Trump Tower meeting where I call that the original sin, where they agreed to the catch and kill scheme with the National Enquirer, and that kind of set the table for the buffet of criminality that Adam talks about that ended up happening over the next few years. But they also sought information about why the National Enquirer would not sell the life rights of Kara McDougal, why they ripped up that agreement despite having reached a written agreement to be able to do so. I mean, a lot of this seems to me, Andrew, that David Pecker, friend and mentor of Donald Trump, is the person who will corroborate very squarely what Michael Cohen said was the original conspiracy.
I couldn't agree with you more. I think it's useful for everyone to go back and think about how we were reporting on this case when we heard David Pecker's testimony, that everyone was sort of taken aback because they went, oh, this is so solid. Here you have a witness independent of Michael Cohen saying that there was an agreement that he had as a principal with Donald Trump as a principal. Michael Cohen was a staffer who was going to carry out the instructions of that agreement. And maybe even more surprising is that Donald Trump's counsel didn't really cross-examine David Pecker in terms of his credibility. So you're left with this kind of jury note saying, tell us about more. We want to be reminded about what David Pecker specifically said. He was the first witness, so this is many weeks ago. But it was very much a little bit like Hope Hicks' testimony, which was also damaging, which is also something that Donald Trump's counsel didn't really challenge. And then finally, just to your law point, New York has this rule, which is that you do have to have corroboration of an accomplice. You cannot be convicted solely, the key word here is solely, on an accomplice's word. I will say that de facto, that is really the federal system as well. Even though in the federal system, we don't have that rule. De facto, you do have that rule. No one would dream of presenting a case to a jury where the only witness was somebody like Michael Cohen, who is an accomplice. You always would have some sort of corroboration, usually very strong corroboration. But I completely agree with you. The note, well, it's just tea leaf reading and it's a first sign. There's no question that if you're the prosecutor, you think this is a good note. It is going to the heart of the case. It is going to a clear piece of evidence that was not challenged. And it also did ask for some testimony from Michael Cohen, which suggests that they didn't write off his testimony as the defense asked them to do.